Further hearing in the appeal, East Asia Company Limited against PT Satria, Tirtatama, Energindo.
Yes, Mr. Howard.
My Lords and my Lady, where we had got to yesterday, we had looked at the evidence, particularly the evidence of Mr. Suharadno, to see the extent to which there was any reliance. Now, as I made clear yesterday, the case on ostensible authority was not pleaded, and there was no evidence of any reliance on any relevant representation. Indeed, the evidence was inconsistent. My Lord, Lord Sales asked how the matter arose in the absence of the pleading, and we've dug out the skeleton argument that was in front of the judge, which, and we have copies, and you will see it was dealt with extremely briefly.
Mr. Howard, we seem to have a technical problem. If you could wait for a moment or two while we get it sorted out.
Oh, okay, we'll do this.
Oh, right.
Okay.
Yes. So can that be done? Can we just one and,
And that's going to be yours. Thank you.
You want to send me the screen?
Start with that. Excuse.
Being an up-to-date online court is supposed to make life simpler and save time for us.
Perils of technology.
You'll notice that those of us who don't bother with the laptop are ready to go.
Apologies. Right. Very sorry, Mr.
No, no need to apologise.
Yes, Mr. Howard.
Yes, my Lord. I was just going to show you how the matter had been introduced into the case, and the skeleton argument that I've handed up, I apologise, it's got some annotations on it, but we're only going to look at one part. I think the annotations must have been by somebody on our side below. But the only bit that's actually relevant is on page 4 at paragraph 12.1.3. Although it's in what is a summary, the point doesn't get addressed elsewhere. And you can see that what was said was the directors who entered into the HOA on behalf of East Asia and Bell had the apparent, or at least the ostensible authority to do so. The plaintiff was entitled to assume that all necessary consents had been obtained, and footnote 5 refers to the presumption of regularity in the indoor management rule, colloquially the rule in Turquin's case. So that, when you see that, and then you remember I showed you yesterday the judgment at paragraph 62 and 63, one sees where things went wrong, because the judge proceeded by reference to the rule in Turquin's case, as it were, establishing the ostensible authority, which is entirely the wrong way round. I'll come back to that point in a moment, but if one then goes to just consider this question of a sensible authority further, the first point is it's common ground that the board of EACL never made any express representations to PT Satria or to Mr. Suharadno to the effect that Mr. Jones had actual authority. So their case is entirely dependent upon an implied representation by conduct. And in the written case at paragraph 36, they put forward, PT Satria puts forward the points that it relies on. So one sees at 36A that Jones and Hatter had for a long time been concerned in the management, and the next one is they'd been over a long period responsible for the running of the business. But neither of those constitute a representation that you have authority to enter into the HOA, a contract for the divestment of EACL's entire business. And indeed, one needs to be careful here not to conflate EACL and BEL. The issue that you're concerned with, or the court was concerned with, was the extent to which there was any representation a representation by EACL, because it's EACL on whose behalf the contract is purportedly being made. The next assertion is that they had titles which indicated their executive responsibility, in contrast to the other directors of EACL and BEL. Now, that is actually, again, because they allied the two, is simply wrong. Mr. Jones and Mr. Hatter were both merely ordinary directors of EACL. The board did have power to appoint people as chief executive or managing director, but it had not done so, so they weren't. And of course, the mere fact that somebody is, in fact, a managing director or chief executive doesn't of itself mean that they have authority necessarily to enter into a particular contract. You'll remember in Akai, the individual concerned was, I think, the chairman and chief executive or some such title. And so the fact that they may have held offices in BEL, so Mr. Jones was described, I think, as the Chief of General Affairs of BEL, is totally irrelevant to the position of EACL. And indeed, it would be an odd suggestion that, let's say you were the managing director, for sake of argument, of BEL, that constitutes a holding out by EACL as to your authority to act on behalf of EACL. Indeed, one would say it's entirely the opposite. The authority that you've been given is to act for the subsidiary. And in our submission, an ordinary director does not have usual or implied authority to bind the company, at least in circumstances where there's more than one director. And even a managing director or chief executive doesn't have authority to make extraordinary decisions. And can I take you to volume 9 of the authorities at tab 35 to Bousted at it's page 3121 of the bundle, and it's Bousted 3029, and at subparagraph 4, individual directors of companies, at least those without an executive role, have little usual authority to bind the company.
I'm so sorry, Mr. Howard. Which page are you on?
I'm on page 3121 of the bundle.
Thank you.
And subparagraph 4 on that page. Individual directors, at least those without an executive role, have little usual authority to bind the company. The managing director has a broad authority, subject to the company's constitution, to make decisions for the company in the ordinary course of business, including to sign checks and bills, borrow money and give security, guarantee loans made by a subsidiary of the company, and agree to indemnify other guarantors and authorize commencement of legal proceedings. He may reimburse himself for expenses on the company's behalf, but should do so by payment through a bank account and not by using company money to pay for private items of consumption. He may direct the method of discharge of debts owed to the company, but not by directing payment to a family member. A managing director may have usual authority to instruct solicitors as to the drafting of his own remuneration contract, a managing director would not have usual authority to make extraordinary decisions that would normally need to be taken by the board, such as the sale or termination of the company's business. And of course that's the type of transaction here, but as I say, here we were not dealing with the managing director. And as to the point that they were the only executive directors, well, that may have been true, but there were other directors that was known to PT Satria. And indeed, what PT Satria knew was, and this we'll see in a moment, is an important point. PT Satria was aware of the position that Mr. Watabe was the beneficial owner. Well, in fact, I showed you that yesterday. Now, the next point they make at 36E is that Messrs. Jones and Hatter had, to the knowledge of the shareholders, historically conducted negotiations to raise funds or find an investor. Now, Lord Justice of Appeal Clark, at 110.5 of the judgment, made the point that, which is entirely right, the mere fact that somebody has authority to negotiate doesn't take the matter any further, because the question is not whether somebody has authority to negotiate, but whether they have authority to contract. And the fact that, well, the earlier MOUs were actually, one was an MOU to which AOL was a party, but they didn't result in a binding contract, and we'll have a look at them. Perhaps let's just remind ourselves of them. They're in volume 5.
I thought we were told that it was a binding contract, but there was a provision for cancellation or something. No.
Then you were misled, if that, or there's been a misunderstanding. If you go to volume 5, at 1427, that's the first one, and the second one is at volume 5 at 1438. Now, the first one is a memorandum of understanding at 1427 between East Asia Company and this other Indonesian company. Now, it's important to note that these documents were never seen by PT Satria, but this document was not legally binding except in a certain limited respect. If you go to page 1430, after paragraph 15, you'll see it says, other than the matters addressed in paragraphs 10 and 11, which the first parties and second parties agree should be legally binding, the terms contained in this MOU are not intended, nor shall they be construed to be legally binding. And this document was in fact, and if one says what are paragraphs 10 and 11, 10 and 11 are on page 1429, and 10 was that the parties agree not to make any public announcements concerning the possibility of a transaction between the parties without prior agreement, and so on. And then paragraph 11 is that an exclusivity period. So in other words, it's rather similar to the situation where you agree to buy a house subject to contract, but you agree, which may be legally binding, that the seller shall take the house off the market, but the actual agreement is not of sale is not legally binding, and so the only document that you have where EACL entered into a memorandum of understanding was not legally binding in relation to the terms of sale, and in fact the terms that were being discussed were, if you look at the recitals on page 1427, were preliminary, and what they were discussing was selling 80% of the shares.
Which page was this?
So page 1427. But there were clearly lots of terms to be discussed relating to the future operation of the company and how people were going to be rewarded. So in other words, what this was really looking at was bringing in this other party to become a shareholder and effectively a joint venturer in the project. But the important thing for this purpose is this tells you nothing about the authority of Mr. Jones. All that you know is that, at best, that he and Mr. Hatter had been responsible for negotiating that, but it hadn't resulted in a contract.
The signatures are 1430 to 1431, is that right? So is this right, that those signing for EACL are Mr. Hatter and Mr. Matsumoto?
Yes.
So Mr. Jones didn't purport on that occasion to sign for...
No, sorry, no, 14... So which page was your lordship?
1431?
Oh, yeah, so 1431, Mr. Jones was signing actually for BEL. And for East Asia Company appears to be Mr. Hatter and Mr. Matsumoto.
Right, thank you.
What? Sorry? Do you want to say something? I think Mr. Todd wants to say something about the document.
Lord, just simply this. I was asked my friend whether he's finished with this document, my lords and my lady. I want to make clear that I am concerned that a suggestion was made I may have misled the court in answer to what my Lord Sales said to my friend Mr. Howard. What I did yesterday, I did not say this was a binding agreement. I took you to page, in fact, it was to page 1441, and I had drawn your attention to a similar clause just above the signatures, or just after clause 17 on 1441, and I said, look, clause 12 is in fact a binding agreement, that is to pay the debts from the execution. That's what I said yesterday. And the other thing I said to my lords yesterday, it was common ground because it's in the statement of facts and issues, that this second MOU was cancelled. And that's common ground. It was found it was referred to by the Court of Appeal. So just so lest the court might think I might have misled the court, so I'm sorry if you thought I was misleading the court. I did not intend to do so.
No, that's certainly with my recollection. In fact, I don't think you took us to the first MOU.
No, I didn't at all.
I wasn't seeking to suggest that Mr. Todd had misled.
I wasn't.
And if he thought I was, I entirely withdraw any such suggestion. But the point is, what is of more importance is this document was not legally binding, save in this very limited respect. It was not a document which was entered into solely by Mr. Jones. In fact, it wasn't entered into by him at all on behalf of EACL. Insofar as he signed it on behalf of BEL, and the reason BEL was signing it was because, as you can see, they were just acknowledging it at page 1427. Title. So they weren't a party to the agreement. They were just acknowledging the agreement. So that, in terms of if one's looking at is there some prior dealing of holding out that you get out of this? No, there isn't, not least because it's never been seen. And when it is, if you do look at it, it doesn't tell you anything. And in fact, the 2012 document had been approved at an SGM.
Sorry, it's a very minor point.
Yeah.
I don't think it affects
Yeah.
anything. But in fact, I
Yes.
think the company is defined as a party and therefore was assuming obligations under the MOU, under paragraphs 10 and 11.
I stand corrected.
So it wasn't purely acknowledgement, but he was signing for BEL, not
He
for
was signing for
BEL.
BEL. And in fact, they had been given specific authority to sign at a board meeting. You have that at 1425. Paragraph 4, board meeting of EACL. So it's extremely difficult to see the fact that this document was entered into constitutes any representation. It was not legally binding, and it was actually executed as a result of specific authorities given by a special general meeting of EACL. As to the other document, which you were taken to, which is at pages 1438 to 1441, that document, firstly, was an agreement between AOL and this other Indonesian company. Insofar as any obligations were, well, I don't think any obligations actually in this were undertaken by EACL, but in any event, it was also not a binding agreement to sell. And
Sorry, aren't there obligations on EACL in paragraphs 9, 10 and 11? Sorry, 9, 10 and 12.
well, I suppose, again, that 9 is not to make a public announcement. 10 is the exclusivity period, which is actually, I think that's actually only really an obligation on AOL, because that's the first party agrees not to conduct negotiations. 12 is obligations on the Indonesian party. So insofar as anything is being done by EACL, it's simply undertaking a confidentiality obligation.
Well, in fact, the penultimate clause tells us that the matters in those paragraphs are agreed by the first and second parties to be legally binding on themselves.
Yes, and that's all. But the important thing is one needs to then stand back and ask, well, why are we actually looking at this? The only reason you would ever look at prior dealings is that what one's looking at, I mean, if one takes the sort of normal case where, let's say you have an individual, say a director, who signs, let's say, charter parties over a period of years, and the company performs the charter parties or whatever it is. Now, even though he may be acting in excess of his authority, but the fact that the company performs the contracts that he's entered into then creates a representation by conduct that he does have authority to do that. In our case, you have firstly, these documents which hadn't been seen by PT Satria, so it's very difficult to see how they can create a representation to them. But insofar as you saw them, they would not create a representation, and this is what they would have to show, that Mr. Jones had authority to enter into an agreement to sell the entire share capital of BEL. And that's the point. And there's a useful summary of the authorities in a decision of Mr. Justice Andrew Smith's in volume 8 of the authorities at, sorry, I've got the wrong reference. Yes, it's tab 25, page 2629. Case called Peck Limited and Asia Golden Rice Company. And if you go to paragraph 67 on page 2654, this is, I think, an arbitration appeal, and you can see it says, AGR's successful argument before the tribunal was based on the course of dealing after May 2005. Now, what's interesting is he says the courts do not readily infer from a prior course of dealing that a principal has represented that a putative agent had authority to make contracts for it. The locus classicus might be the observations of Lord Justice Romer in Slingsby, which was cited by Lord Justice Robert Gough in Armagas. The fact that the employer of the putative agent had on numerous occasions employed the putative agent to prepare checks for signature cannot amount to a holding out by them of him as their general agent for that purpose. I've explained why I'd be more reluctant to draw such an inference against an apparently hierarchical entity such as Peck. AGR's case here is pleaded in two ways. One, that by their conduct in concluding contracts, Peck had held out Mr. Jane as their agent to negotiate and to conclude contracts, but by their acquiescence in the earlier contracts, Peck clothed Jane with authority to negotiate and conclude the contracts. In submissions, Mr. Collett also relied, without any objection from Mr. Brindle, on the fact that Peck were apparently content to deal with AGR with regard to contracts and amendments to them. For example, amendments to prices, shipping periods and destinations, though through Mr. Jane in particular, and PGS more generally. Accordingly, he submitted a third party in the position of AGR would reasonably have understood, and AGR did understand, Jane had authority to conclude contracts on Peck's behalf. It is not enough that AGR understood this to be the position and that they were reasonable to do so. The first question is whether Peck so presented Mr. Jane by their words or conduct, including silence or omissions. And here all that matters is what was done by someone who had actual or apparent authority to speak or act for Peck. Moreover, it's nothing to the point that Peck presented Mr. Jane as having authority to conduct negotiations. The question is whether he was presented as having authority to conclude contracts, and more specifically a contract such as the purchase agreement. I accept that by a consistent and regular course of dealing in which they fulfilled contracts made in their name by a putative agent, a principle could be taken to have represented to counterparties the agent had authority to commit him to such contracts. However, given the court's reluctance to infer a representation of this kind, I'm persuaded by Mr. Brindle that no such inference is to be drawn in this case. As in Slingsby, the fact that Peck had on occasion in the past fulfilled contracts made by Jane purportedly on their behalf is not enough on the facts of this case to amount to a representation that Jane had authority to conclude contracts for them. Peck's conduct is readily, and to my mind more readily explicable, as reflecting their decisions to ratify particular contracts made by Mr. Jane in their name. Now, we're a million miles from that. We don't have a course of dealing. So even where you've got a course of dealing, it can be difficult. But simply pointing to this one-off contract in the circumstances that we see here is nowhere nearly good enough. Now, and Justice of Appeal Clark also made the point that at 110 subparagraph 8, he said that this is not a case where the making of an HOA of this type could be said to fall within the usual authority of a single director, such as Jones. The subject matter was the sale of the sole asset of EACL for a consideration apart from the payment of Bell's debts, which might well never materialise, and if it did, would be payable at some distance in the future. such a power would not ordinarily be exercisable by a single director, and in any event the bylaws make plain the decision of the board was required. Now, all of that is right, and of course, Mr. Sudardno was entirely aware of all of that. Now, it is common ground that in determining whether an agent has an alleged agent has ostensible authority, you have to assess the nature of the transaction in question, and the more unusual the transaction, the less likely it is that you would be able to establish ostensible authority. Now, the argument that has been made both orally and in writing is that there was nothing unusual about this transaction. In our submission, a situation where you are selling off the entire assets of a holding company, and where the holding company is owned by someone with whom the potential purchaser has had no dealings whatsoever, in our submission that is something self-evidently unusual. When you put that together with the knowledge of what is in the articles, we would suggest it's very difficult to see how one could say this was not unusual. And Justice of Appeal Cavalier also made the point at paragraph 178 of the Court of Appeal judgment that you need to take account of the particular circumstances of the company. It's perhaps worth starting at 177. This is under the heading, the distinctive role of employee directors in a closely held trading company. So he makes the point that Jones and Hatter were directors employed to manage the affairs for the benefit of the company's ultimate beneficial owner, Watabe. The fundamental issue in this case, whether these directors, acting against the wishes of EACL's sole shareholder, had validly transferred EACL's major assets to the respondent. Just stopping there for a moment, I will show you shortly the correspondence where it was made clear that Mr. Jones and Mr. Hatter were not to sell off the shares. And that's part of what makes all of this fairly extraordinary, what they were doing.
Correspondence between?
Correspondence to Jones and Hatter.
From
People representing Mr. Watabe.
So that's not a matter which affects...
No, it's not a matter but the point that the judge here was making was simply that this transaction, as a matter of fact, was one that was being done contrary to the express instructions of the beneficial owner.
Yes, but they had asked, he was a sort of absentee landlord, a corporate equivalent of an absentee landlord.
I'm not sure
in the sense that he hadn't responded to the cash call.
He hadn't responded to the cash call, but at the date they were doing this, because I'll show you the correspondence. He'd made it clear that there was to be nothing to be done because they were about to be removed as directors. So the context in which they sign up the HOA on the 27th of February and then they hold their board meeting on the 1st is that they've been told they're going to be removed on the 4th. And on the 28th of February, they're told you should not do anything relating to these shares.
I'm quite interested, as you say, this is rather an extraordinary feature of this whole thing, that the actual beneficial owner, Mr. Watabe, he was saying that he didn't want to sell, and they shouldn't sell, but later on, when we get to the meeting of March, he sort of doesn't even know it's happening, I think.
The other director...
The other director did.
Yeah, Mr. Watabe doesn't know.
But there's also a question about how much Satria knew about all this.
No, my lord, it's...
I mean, what I'm interested in, I mean, the facts are quite messy. I mean, they're set out in the statement of facts, hopefully, is what its legal significance is.
My lord,
I mean, don't come to it at some point.
Let me answer that straight away. What one needs to be careful about is not confusing different issues, and maybe I have just been guilty of confusing things. At this stage of the argument, one is simply concerned with what was the outward appearance to PT Satria. Yeah. So internal communications of which they're not aware are irrelevant to the question of ostensible authority. And that's what we're looking at
Yes.
now.
But the point you're making on now, which is the concurring judgment about the special character of...
That's an ostensible authority.
Yes, that is, and that was known.
Yeah, I just, perhaps because Council's tendency to slip in prejudice, it's rebounded against me in that I've then caused us to divert onto a different
No, it's good prejudice.
Yeah.
It's just a matter of where it takes you in law. That
No, well, it doesn't take me in law anywhere, and I accept, in relation to ostensible authority. The fact that Jones and Hatter were up to no good, or that's what would appear, doesn't take me anywhere at this stage when I'm considering what representation EACL had made.
Nor does it make this an unusual transaction. I mean,
No.
that must be judged objectively, mustn't it?
That has to be judged objectively by what PT Satria knows.
Yeah.
But I mean, if one says, what do they know in relation to that, my lord? They know that this company, EACL, is owned by Mr. Watabe. They know that they haven't dealt with Mr. Watabe. They know that EACL is actually standing to get nothing, at least immediately, for disposal of these shares. They know that this is the sole asset of EACL, and they know that Mr. Jones and Mr. Hatter stand to benefit. They know all of that.
And they also know what the bylaws say.
They also know what the bylaws say. So it's actually what they know is all within that fairly narrow compass. But we say when you look at all of that, this is patently an unusual transaction. But and just before I move on to the point that I wanted to bring out of Justice of Appeal Cavalier, when we're considering separately the question of what happened at the board meeting as to whether that was a properly constituted board meeting, there it is appropriate to look at the internal communications. And so, because the board meeting, as I said yesterday, that you have to look at, as it were, hermetically sealed, and you're just asking, was that a proper board meeting? And if, as a matter of law, it wasn't, then the decisions there are of no relevance. Now, the point that I was seeking to bring out is at 178 of Justice of Appeal Cavalier, where he, having at 177 pointed out that this was a closely held company, says it doesn't appear that this important dimension received similar emphasis before Mr. Justice Hellman at trial. The actual and apparent authority of directors is not simply informed by a company's bylaws, but also by the character of the relevant company. Directors of a fund company whose shareholders are numerous and have no expectation of participating in the running of the company have a generous margin of appreciation in making significant decisions, particularly in the context of insolvency. In my judgment, the apparent authority of employee directors of closely held companies, such as EACL and Bell, is far narrower, and their purported consummation of substantial transactions, even after the onset of insolvency, warrants heightened scrutiny by counterparties to such transactions and by the court. So, in my submission, that is right. If when you're looking at PT Satria dealing with EACL, because it's EACL in particular, that where you see employee directors selling off the entire assets, that's something which obviously calls for scrutiny, particularly where you've got the board minute, the bylaws, which tell you how the things are to be done. As I think Justice of Appeal Clark made, a point he made, which is really the obvious one, if you would wanted to satisfy yourself this was being done properly, the thing you would ask for is to see the board minutes or the resolution of the company. They didn't do that here. What they did was something quite different. You'll remember Articles 6 and 7 of the HOA, where they asked for warranties, effectively, from Jones and Hatter. Now, there is, in the written...
That might in itself be thought to be a rather unusual feature of the transaction.
I'm sorry.
That might be thought to be an unusual feature also.
Yes, it was.
I mean, one doesn't normally see in contracts guarantees and warranties and indemnities being given by the directors who execute it, that they actually have authority to do so.
No, well, my Lord, that is the point that Justice of Appeal Clark made, that it's at 100... Yeah, he made it to 132D. This is where he was dealing with the facts putting people on inquiry. But he made the point at D that Satria knew Jones and Hatter required the approval of EACL for the HOA, as Clause 6 of the HOA confirmed. Now, just stopping there for a moment, Mr. Todd said, well, that's wrong. I'm not quite sure why he says that. The PT Satria knew that Jones and Hatter required the approval of EACL because that's what the bylaws told them. Clause 6 of the HOA purported to confirm that they had got approval. And then he says the obvious way to satisfy yourself was to have a certified board resolution or a legal opinion confirming authority to execute the HOA. Actually, a legal opinion might not be any good. I mean, I think Lord Sales will remember the debate we had in law debenture, which we should be revisiting at the end of this year, for those of you who are going to be sitting on that, where there were legal opinions about the authority of the Ukrainian Minister of Finance. But if the legal opinions are wrong, it doesn't actually take you anywhere.
But yesterday we were discussing whether or not there was a reason why, for the gap between the 27th of February and the 1st of March, and we know this clause was given, and it may have been the plan all along that there should be a board meeting.
Well, PT Satria, again, if we focus on what they knew, their evidence is they didn't know anything about a board meeting. So that, whatever... I think your ladyship's question was why, when they drew up the heads of agreement, did they not also draw up the share transfer form? Now, I don't know. What we know is that they drew up the share transfer form prior to the board meeting, because the board meeting purports to approve the share transfer form. But why they did that, didn't do it on the Friday and did it on the Sunday, is
Obscure.
Not
on the evidence.
Not in the evidence, and not something that I can assist you on. But what the Court of Appeal found was that the reason all of this was being done, I think Mr. Todd sort of say, oh, there's nothing unusual about things being done on a Sunday, and in Bermuda maybe people aren't used to working on a Sunday or something like that. The point is, the reason the Court of Appeal concluded this was being done in this way was because of the imminence on the following Wednesday of their being removed. That was the urgency. It wasn't because I think Mr. Todd sought to suggest in argument, oh, well, there must have been something about BEL, risks of it losing its license. There's no evidence of that at all. It's not that there isn't any evidence that the Indonesian authorities were about to do something and you had to get these debts paid. And what's more, they haven't been paid. That's also recorded in the judgment.
Could you remind me where the Court of Appeal say that it's because they were proceeding in a hurry because they knew they were about to be removed from the board?
Yes. It's actually... do you still have paragraph 132D?
Yes.
If you go to E, you see the HOA was premised on the assumption the parties intended to negotiate a final agreement. It was executed on Friday the 27th. Mr. Suhardno said in his statement, this negotiation did not occur because of the urgency of Bell's financial situation, and it was never intended that the core terms would be renegotiated. And just stopping there for a moment, I think that may actually be part of it, which explains, in answer to Lady Arden, that if you look at the HOA, it plainly contemplates further negotiation. And so here Lord Justice Clerk is reciting what Mr. Sir Hardno says, and he says that in consequence, on the 1st of March, PT Satria acquired the Bell shares via a certified share transfer agreement. The notices convening the meeting were given on Saturday the 28th. On that basis, Satria must have taken the view that within 24 hours of executing the HOA on a Friday, Bell's financial situation had worsened to such an extent that the board meeting of EACL approving the HOA and of Bell approving the transfer must take place by Sunday the 1st of March. This is incredible. The real reason must have been that Jones and Hatter were both going to be removed on Wednesday the 4th of March as directors of both companies. Mr. Sahardno accepted in evidence there was no particular reason so far as Satria was concerned why the HOA had to be executed urgently.
That was Satria, though. That was, so far as Satria was concerned.
Yes, there was no urgency.
Well, the answer that's then quoted is quite an interesting one.
Yes, that's then Mr. Hatter, and you can see we did it before the 4th. We weren't sure what was going on legally. Watabe had retained ISIS. They were challenging the removal of Yamura and 2 Matsumotos. And you know, they submitted the requisition. That's the requisition to get rid of Jones and Hatter. So better, you know, try to conduct our business sooner than later. No, I mean, there it is. I mean, you could say he's hung himself with his own words, really. Now, what I've been focusing on so far is whether there is any representation, and that's, if there's no representation, that's the end of an ostensible authority case. And you already have my submission that Mr. Sahardno, you have my submission that none of this constitutes a representation. Then you'd have to consider whether there was reliance, and I took you yesterday, and I won't go back to it, to the evidence of Mr. Sahardno, which entirely undermines that. Now, and you'll remember in Mr. Sahardno's cross-examination, he says the only reason he did this was because I trust Jones. Now, my Lord.
And that means your submission is that he was relying on Mr. Jones and not on any representation by EAC. Yeah.
The evidence he gave was unequivocal about that. But now, yesterday I reminded you of paragraph 110 to paragraph 100. Yeah, if you go to paragraph 110, I'm sorry, I misspoke, of the Court of Appeal, at subparagraphs 1 to 3, the Court of Appeal, or Justice of Appeal clerk, at 1 he's referring to, I won't read it out, he's referring to the knowledge of Mr. Sahardno as to the position under the bylaws. And then 2, he explains the position that there was no resolution or board minute. And then he makes the point in the second sentence of 2 that Satria was not entitled to assume that such a delegation had taken place, and refers to the Houghton case. Then he refers to the fact that Mr. Sahardno accepted he'd never seen any document. And so here, at 110, he's of course referring back to the findings of law that he'd made at 102 to 105. Now, we then need to understand, well, what is it, if any, what is the challenge that is made to particularly the law at 102 to 105. And what you'll find is there's been some inconsistency in the position being taken by the appellant. So if you go to the written submissions, they seek to deal with this point at paragraph 32 and 33. And you'll see that what they say about the law is, it's either confused or wrong. So what they say at 32, they say that in this regard, at 110.2, this is referring to Justice of Appeal Clerk, in the context of the absence of any board minute available to PT Satria, Justice of Appeal Clerk relied on Houghton, Freeman and Lockyer in support of the broad proposition that Satria was not entitled to assume that such delegation had taken place. And then they say that the reliance on those authorities was misplaced. Houghton was not a case of ostensible authority at all, but a case on the indoor management rule, in Turkman's case, and they refer to Akai. Then they say it's clear from the dictum of Lord Justice Diplock in Freeman and Lockyer, which they then quote, if the act is one which would ordinarily be beyond the powers of such an officer, the plaintiff cannot assume the directors have delegated the officer the power to do that. That this is an application of the principles discussed in 28 and 29 above, namely that it was unreasonable for the third party to seek to rely on the representation and the ostensible authority of the agent in respect of an unusual transaction, and it has no application in the present case. Now, you might just want to note, we'll come back to it, that at this stage of the submissions, Mr. Todd accepts that one of the questions is whether reliance on a representation was reasonable. When we come to consider Akai, we'll come back to that, but you'll note that he quotes, he refers back to paragraph 28, which refers to the Raffaella and the dicta of Lord Justice Brown Wilkinson, which are extremely well known, which shows that where you have a case based on representation, reliance on the representation has to be reasonable. So when we come to consider, insofar as any of it's relevant on this case, the Akai line, you will need to note that. But just taking this point at paragraph 33, it seems to be a complete misunderstanding of what what both Mr. Justice of Appeal Clerk said, and indeed what you get out of Akai. So if you go to volume 7 of the authorities, where we find Akai at tab 12, page 2139, the relevant part of Akai for this purpose that's being referred to is paragraphs 58 and 59. And you recall that Justice of Appeal Clerk...
Sorry, could you just give me the page references for those?
I'm sorry, Mark?
Could you please give me the page reference?
Yes, the page reference, I do apologise, is page 2163.
Thank you.
But Justice of Appeal Clerk at paragraph 105 actually was referring to the quote from Akai at paragraph 59. So you can see at paragraph, at this stage in the judgment, and again, it's that when one's looking at this, one needs to bear in mind what is being spoken about. What his lordship, Lord Newberger, was talking about was the state of mind of the person alleging apparent authority, which is something we come to separately. At this stage, one's considering the question of what representation there was by the alleged representor. And so at paragraph 58, when he's dealing with Houghton, what he was dealing with, and I think you've already read that at paragraph 58, was dealing with the dicta there about the knowledge of the representee. So, and perhaps it is worth reading. He says, another English Court of Appeal decision relied on by Akai is Houghton. There is no doubt but that in that case, the test propounded by the court was that proposed by Mr. Cosmin. However, it was a case involving the so-called indoor management rule, decided at a time when a person dealing with a company was deemed to know of the terms of its memo and arts, which is, of course, no longer the law in Hong Kong or England. A passage at 267 in the judgment of Lord Justice Sargent indicates an acceptance of a difference between the indoor management rule and apparent authority. But it's the next paragraph that's the key. That difference was, in my opinion, well explained by Mr. Justice Dawson in Northside Developments, in a passage which neatly distinguishes between the rule, that's the indoor management rule, and apparent, or as he called it, ostensible authority. The correct view is that the indoor management rule cannot be used to create authority when none otherwise exists. It merely entitles an outsider, in the absence of anything putting him on inquiry, to presume regularity in the internal affairs of a company when confronted by a person apparently acting with the authority of the company. The existence of an article under which authority might be conferred, if it's known to the outsider, is a circumstance to be taken into account in determining whether that person is being held out as possessing that authority. In other words, the indoor management rule only has scope for operation if it can be established independently that the person purporting to represent the company had actual or ostensible authority to enter into the transaction. The rule is thus dependent on the operation of normal agency principles. So what is clear is that this is a statement of law, of general application in relation to law of agency and ostensible authority, and for that purpose you have to establish a representation, and you can't use the rule in Turkmen, that's what these authorities are saying, to, as it were, pull you up by your bootstraps to establish.
You have a self-authorising agent.
Yeah.
If that were so. I mean,
exactly so.
Yeah.
So the point that was made by in the written argument, somewhat unclear, but it's simply wrong insofar as it's seeking to criticise Justice of Appeal Clark. Now, in his oral submissions yesterday, Mr. Todd took an entirely different line, and it's what I would describe as his hey presto point, which he made. And you'll remember Mr. Todd took you through the bylaws of the company, the articles, and he said, look at the definition of board, and then he said a board meeting could be quorate if you had two directors, and therefore, somehow he says, because we have two directors here, that must mean that it's reasonable to assume that the two directors acting here, although it's only Joe knows who signs, have authority. Now, the simple answer to that is that this is entirely inconsistent with these authorities. It's entirely, in order to establish authority, you have to show that there has been a board meeting and that you've got a resolution of the board or a minute in which authority has been delegated. Absent that, all you're saying is Jones and Hatter could have got authority, not that they in fact did have authority. So, although this wasn't the way it was put in the written case, in his oral case, Mr. Todd appeared to be going back to actually the very way the matter was put when it was introduced before Mr. Justice Hellman, which is simply I can rely on the rule in Turkwind, which is, as I've already shown, contrary to authority. And so Justice of Appeal Clark and the rest of the Court of Appeal were entirely right. Now, in any event, as I have said, the evidence of Mr. Suhardno is fatal to any argument that they did in fact rely. Now, I suspect your lordships are entirely fed up with having looked at Akai, but I think I ought to show you on this point a further passage from Akai of Lord Neuberger. So if I could ask you to go back to, it's 712, and the passage for this purpose that I ought to show you is at page 2167. Which is where his lordship dealt with evidence of reliance. So at 72, he says, given that apparent authority is a species of estoppel by representation, it follows, as Lord Justice Diplock said in Freeman and Lockyer, the third party must establish it relied on the apparent authority of the alleged agent before it can succeed in establishing its case. The issue which divides the parties is the quality of the evidence which the third party has to lead to establish reliance. Inevitably, that is a fact-sensitive issue, but I detected a suggestion in Akai's case. It's positively necessary for a third party to establish that he positively relied on the apparent authority in every case. In Nationwide, Building Society and Lewis, a case concerning the holding out of a person as a partner in a firm, Lord Justice Peter Gibson said, "It doesn't seem to me to be impractical or unjust for the law to require a person claiming an estoppel to have to prove in a partnership context what he would have to prove in other contexts. Given that reliance is a necessary requirement, it's not obvious there should be a presumption in favour of the person who claims reliance and is in a better position to know whether he did rely on the holding out and who should thereby be able to prove it. Of course, there may be circumstances from which it would be appropriate for the court to infer there was reliance on holding out. As stated in Spencer Bauer, though on questions of fact the onus will be on the representee, it may happen that the probability of inducement from a given set of facts is so great, or in other words, the materiality is so plain and palpable, as to justify a finding of the inducement itself merely from the circumstantial context, but it must be remembered the inference so made is one of fact, not of law. While there's nothing with which I would fundamentally disagree in those observations, I consider that their thrust could risk placing too high a hurdle for third parties seeking to establish a claim in apparent authority. In Silver and Ocean Steamship, it was held that taking of a bill of lading was sufficient evidence of reliance on it to raise an estoppel. The point was dealt with very shortly in the judgments, effectively on the basis it was obvious. Thus, Lord Justice Slessor said, the appellant took the bill and may be assumed to have relied upon it to his detriment in the absence of any evidence to the contrary. In my view, once a third party has established the alleged agent had apparent authority, i.e. the principal held out the alleged agent as having authority to bind the principal, and that the third party has entered into a contract with the alleged agent on behalf of the principal, then in the absence of any evidence or indication to the contrary, it would be an unusual case where reliance was not presumed. Now, in our case, we say that there is no representation here, so you never get there. But secondly, insofar as, and this is somewhat tentatively put, but insofar as there is any presumption, it's simply looking at an ordinary circumstance. So if you have a situation where there is a holding out by the agent, and that is clear, and you then deal with it, let's say you enter into a contract because, say, a contract of ordinary sale of some goods, a company that sells goods, and you're dealing with the sales director, it's not really very difficult for you to say, well, I was dealing with the sales director and I presumed that he had authority. But in our situation, where it's an unusual transaction, and then you have Mr. Suharto's evidence, there is no room for any presumption, not least because you have evidence or indications to the contrary. But I wanted to show you that so you could see those dicta.
And would you say there was evidence to the contrary in the light of Mr. Suhardino's?
Yes, exactly.
This is the evidence you took us to yesterday to the effect that the reason why he proceeded on the basis that Mr. Jonas had authority was that he had formed the impression that Mr. Jonas was a trustworthy person on the basis of their previous dealings.
I mean, what he's actually saying is, I full well knew that Jonas did not personally have authority unless he had authority delegated to him by the board. Because I thought Jonas was an honest guy, he wouldn't break the law. In other words, I assumed that he had gone and got his authority. But that's not a case of holding out by the company. That's a case of holding out by Mr. Jonas. Now, in our submission, that's perfectly simple. And as I explained yesterday, in the Court of Appeal, an argument was being made that Jones and or Hatter had authority to communicate the authority. That point has, that featured in the grounds of appeal, but that point is not featured in the written case or in the oral argument. So I'm treating it, no, I'm grateful to Mr. Todd that point is not pursued. So in our submission, the conclusion at this stage of the argument is that Mr. Jones did not have ostensible authority. There was no representation, there was no reliance, and so the HOA was not binding. Now, the issue about people being put on inquiry has come into this case in different ways, and one has to keep them separate in one's mind. At this stage, the put on inquiry point arises in this sense. If the court was against me and said, yes, there was a representation or something that was capable of being a representation of authority of Mr. Jones, then the question is whether, and the court was against me on reliance, the question would be, was the reliance in fact reasonable? And we say it was not. Now, can I first, though, just address how this arises as a matter of law? And in our submission, that there has been some confusion that has crept into the law here. Now, if we just take the position of the parties before you for a moment, if we go to the written case of PT Satria at paragraph 44, page 1862, well, it's actually, before I do that, can I ask you to go to Justice of Appeal Clark's judgment? I think I did show you this yesterday, but it's just helpful to frame the discussion. So you'll remember that he had found that there was no ostensible authority, and that was his conclusion at 124. It's earlier. That he had found
the last sentence of 110.
110, exactly. 111, he's dealing with the authority to communicate point, which is no longer live. And then at 126, he said in any event it was being said that PT Satria was put on inquiry. So this was part of an obiter discussion. And then you'll remember he reflected at 130 on the fact that Akai, insofar as it was putting a different test to the put on inquiry, was controversial. But he said, because he didn't want to lengthen the judgment effectively and it would all be obiter, he was prepared to assume Akai was correct, which led to him at 136 saying if it was the Akai approach, he wouldn't have said that Satria was disentitled, but if it was put on inquiry, he would. Now, when one then reads the written case of PT Satria at paragraph 44, it appeared that they were adopting the same approach as, they were not adopting the approach from Akai, but they were adopting the put on inquiry approach. Because you see at paragraph 44, where they say a person dealing with an agent will be precluded from relying on the agent's ostensible authority if he knows or has reason to believe that the agent did not have actual authority, and they rely on criterion. And then when you go to paragraph 47, they seem to be treating reason to believe or put on inquiry as exactly the same, and that is as synonymous, and that is why they then approach them on that basis. Now, be that as it may, one then, before we go any further, in order to frame this, if I can remind you of paragraph 28 of their written case.
Yeah.
Where they say Mr. Justice of Appeal Clark failed adequately to consider not only whether AEACL's acquiescence in Jones acting on its behalf represented to Satria that Jones had authority, but also the reasonableness of Satria's reliance on the representation. So at this point, at that stage of the submission, by reference to the Raffaella, they recognise that English law does require that the representation should be reasonable. The reliance should be reasonable. Now, the Raffaella is in volume 7 of the authorities at tab 3, and it's probably worth turning it up just to see the position slightly more fully. At page 1954 is where page 41 of the law report is where the discussion takes place. And you can see, and you want the left-hand side, the paragraph beginning, it's important. It's important to bear in mind the doctrine of holding out as a form of estoppel. As such, the starting point is the principal must be shown to have made a representation which the third party could and did reasonably rely on, that the agent had the necessary authority. The relevant inquiry, therefore, in all cases is whether the acts of the principal constitute a representation that the agent had a particular authority and were reasonably so understood by the third party. This requires the court to consider the principal's conduct as a whole. In many cases, the holding out or representation by the company consists solely of the fact the company has invested the agent with a particular office, managing director or secretary. For example, British Bank of the Middle East, the only holding out by the defendants to the third party was to invest somebody with the title branch manager, which enabled him so to describe himself in correspondence, relied upon by the third party. In such a case, the only representation which the third party can reasonably rely on is the representation that that person has the powers normally or usually enjoyed by a branch manager. Just interposing here, in this case, the only representation on which PT Satria could rely was that Mr. Jones had the powers of a director within the bylaws as they'd seen. In other words, he didn't have the power to enter into the contract. Anyway, therefore, in such a case, the only relevant inquiry is as to the powers normally employed by branch managers in general. But whereas in the present case, the holding out is said to consist of a course of conduct wider than merely describing the agent as holding a particular office, although the authority normally found in the holder of such an office is very material, it must be looked at as part and parcel of the whole course of conduct, in order to decide whether the totality of the principal's actions constitute a holding out as possessing the necessary authority. I therefore cannot accept either of the ways in which Mr. Stamler put his case. It's not right in this case simply to inquire what is the normal authority of documentary credit managers in general, nor is it right to start by seeking to establish the normal authority of documentary credit managers in general, and then looking to see whether there are any additional factors which alter the position. The only correct approach is the one adopted by the judge, which is to consider the whole of Refson's conduct to determine whether it amounts to a holding out. And so one sees you look at the whole conduct, and then you've got to decide whether or not the party was reasonable to rely on that. Now, the test which was proposed in the written case of PT Satria, which is the, by reference to the criterion case of reason to believe, in our submission it's difficult to see that that is any different from put on inquiry. I think in his oral submissions, Mr. Todd said, well, reason to believe is actual knowledge, but plainly it isn't. It's looking at something objective.
I think he said akin to.
Yes,
actual.
but it plainly it isn't. It's whether, on the facts that you do know, you have a reason to believe that somebody doesn't have authority. It's an objective standard, and in our submission it's exactly the same as put on inquiry or the reasonableness test. Now, you have seen that if Akai was intended to introduce a different test, that's
Sorry, I'm not quite with you there.
Yeah, I'm sorry.
Reason to believe, sure, is a stronger test than put on inquiry.
What?
Put on inquiry is simply saying there are reasons which justify you looking into it, which may result in your having reason to believe.
Well,
It's a sort of step before it.
in my submission, all the cases, what one is looking at is whether objectively it was reasonable for you to treat somebody as having authority.
The way it's put in Raphael, I can understand that.
Yeah.
It's very straightforward.
Well,
Once you get into these little refinements, it all becomes rather confusing.
Well, in relation to what we're talking about in this case, that's, the question here is actually not there's a danger of separating things out. And here, ultimately, what you're asking is, was it reasonable for P.T. Satria to believe that Mr. Jones had, was it reasonable to believe he had authority? And in our submission, firstly, there wasn't any representation. But even if you say there's something which could constitute a representation which would be very weak, in our submission, in the context of this judgment, of this transaction, it wouldn't be reasonable for them to simply proceed. And indeed, as we know, they simply did proceed on the basis that
yes, that's a different question. Was it reasonable to believe that they had authority as a sort of positive test? But I think it may go further than that. Was it reasonable for them to go ahead without investigating further whether he had authority, which may be enough for your purposes?
Yes. Well, in my submission, once you're put on inquiry, objectively, it's no longer reasonable for you to proceed without inquiring further. Therefore, it's not reasonable for you to rely on the assumption of somebody having authority. That's it.
And is that's not the same as the Akai test?
Well, the Akai test, if one, well, I said we wouldn't go back to it again, but it's probably... The Akai, it becomes like an old friend as ever in these cases. It's in 712. And it started at 2161. Now, of course, this is from an eminent judge, obviously the former president of this court, but, and I'm not saying it shouldn't be afforded, of course, respect, but as I think it was once said of Lord Bingham, Homer does nod occasionally, and the fact that the argument was presented by Mr. Sumption, as he then was, doesn't make the argument any better, other than that it was obviously articulated extremely well. But there's a difference between arguments that Mr. Sumption presented and judgments that he gave as Lord Sumption.
Well, actually, I remember taking issue with him over his use of the word irrational
Yes.
in a judgment
Yes.
outside the realms of public law. So this isn't the only example.
Well, I also had the pleasure of being led by Mr. Sumption, as he then was, on a number of occasions, and succeeding in arguing points which I personally thought were unarguable and persuading the court they were right. But that was because of the power of his argument and intellect. But I think one...
But I mean, my Lord reminds me, there is quite an interesting judgment of Lord Sumption in this court, where he distinguishes between irrationality and unreasonableness in a way which not all would necessarily
No, well, I remember I
go along
dissented.
with.
Yes.
Yes.
But the point about Akai and this passage is that you'll remember that this concerned a transaction where just reminding myself what the facts were. The individual involved, I think Mr. Ting, who yes, it was all about something called a switch transaction. Yeah, and Mr. Ting was the executive chairman and chief executive officer of Akai, but the transaction was so odd that the court held that it wasn't one within his apparent authority. You see that particularly at paragraphs 87 and 88. But what in our submission, where Akai at this stage goes wrong, and it may have been because the case was also considering knowing assistance, when dealing with knowledge, it hasn't been contextualized by reference, for instance, to the Raffaella and the authorities showing that reliance has got to be reasonable. And so what the arguments being put forward here were the extreme on one side, Mr. Sumption's irrationality, and then Mr. Cosmin, on the other hand, was arguing for unreasonableness. But what the court does not seem to have looked at, and you've seen the relevant parts, does not seem to have looked at, for instance, the Raffaella, nor, it's interesting to note, if you go to the Houghton case, which is...
Sorry, can I just ask a technical point? In
Yes.
view of the conclusion that was reached in 87 to 88, technically is what is said by Lord Neuberger at 49 and following about the standard of inquiry obiter? Because since there was no ostensible authority, it's not reasoning that was critical to the decision in the case. Sorry, I hadn't appreciated that before. I probably should have read Akai more carefully. I just wondered what the technical position was.
I think that's probably, I'm not sure one could say it was obiter in the sense that, I mean, it's part of his reasoning, although on the facts it doesn't make any difference. But I mean, I think it certainly wasn't essential to the findings ultimately. I'm sorry. Thank you. I'm reminded that I should stand corrected that the Raffaella was referred to at 67. Yes. But the thing is, see here, at this stage where he refers to them, he is referring to them, I think, for a different purpose. And that's what you have to be quite careful. Mr. Todd, in his submission, said, oh, this case was referred to and that case was referred to by Lord Neuberger. But you have to see what he's dealing with at different stages. So at paragraphs 49 onwards, he was dealing with the state of mind of the person alleging apparent authority. And that ends at 62. He then is dealing with a different question after 62, which is, can an agent clothe himself with apparent authority? So one of the odd things is that he does refer to the ocean frost, which is also an important decision. You'll see what Lord Justice Robert Goff said, and the Raffaella, but he's referring to them here for a different purpose, which is in relation to somebody clothing themselves with authority. And that is, I think, part of the critique of the judgment is that his lordship has looked at the various company cases and thought, because they are about Turquin's case, that somehow that makes a difference. Whereas the point you'll see in the extract from Bousted, where the authors have a fairly trenchant criticism of this judgment, is that he has simply overlooked the general law relating to representations, and that the test is one of objectivity, and whether, firstly, objectively a representation was made, and secondly, objectively, was it reasonable to rely on it? Yeah. And so in our submission, this is something where something has gone wrong. Yeah. The authors referred to this as a bolt from the blue.
So far as Raffaella is concerned, the passage which Lord Neuberger is referring to, at paragraph 69,
yeah,
where it says the observations were arbitrary and not supported by the other judgments, and Lord Justice Carr had taken a different view. That's not the passage that you cited.
No, that's exactly.
It's a passage dealing with a different point in time.
Exactly. That's my point. So saying, that, oh, well, these cases are referred to, but they're being referred to in a different context. And with respect to Lord Neuberger, he has overlooked that these cases, and I'm going to show you both the Armagas case and the Raffaella, and show you what they said on this point. Yeah. So, but can we look first at tab 10 at Houghton again, at page 2109 in the bundle, because at page 2122, Lord Justice Banks, at the foot of the page, was considering the law of ostensible authority, and you can see he said there that the plaintiff's second ground of claim and the defence were rested upon a rule of law laid down in Mahoney and other similar cases. And two sentences on, he says, the rule and the application of the rule were recently discussed in Underwood, where the authorities are collected. Those authorities, I think, make it clear that in order to establish a case which falls within the rule, it's essential that the person who claims the benefit of it must A, prove he relied upon the ostensible authority which he sets up, and B, must not have been put on inquiry as to whether the relevant transaction was in order. Now that is what is, in our submission, is, that's back in 1926, and that's long been regarded, prior to the dicta you see in Akai, as a statement of the position in English law. And you will see that reflected in the judgment of Lord Justice Robert Goff, as he then was, in...
Sorry, can I just check?
Yeah.
The rule of law laid down in Mahoney, is that a sensible authority? Sorry.
Yeah, that's what he's talking about. It's
yeah,
all about
not
authority, and that's why he then summarises it here.
Right.
And then if you go to the ocean frost, which is at tab 4 of this bundle, page 1963 of the bundle, otherwise known as the Armour gas case. The relevant part for this purpose is in the Court of Appeal judgment of Lord Justice Robert Gough at page 1980. At letter G, where he said, I wish to add 2 footnotes to this section of my judgment. First, Mr. Pollock relied strongly on the extraordinary features of the 3-year charter, secrecy, minimum charter rate, and the plaintiff's option to cancel, as in any event putting Mr. Jensen and Mr. Danisbo on inquiry. I have no doubt that is right. See Houghton. And he quotes the bit I've just shown you. In other words, the facts of the ocean for us don't matter for present purposes, but the approach that one sees there, that's the question as to whether you're put on inquiry, one sees endorsed by him. Now, the cases that were being looked at in Akai, and where Lord Neuberger was saying, well, these are cases about the Turkman's case. What is unclear, or what doesn't make sense, is why that puts them in any different position. You'll remember, we've already looked at the well-known passage, that you can't rely on the rule in Turkman's case to create ostensible authority where there isn't any. But what those cases are also saying, well, if you're put on inquiry, irrespective of the rule in Turkman's case, i.e. that you're entitled to rely on indoor management, if you're put on inquiry, you can't rely on that. And there's absolutely no reason why the law should be different as to whether you're relying on some indoor management or you're saying I'm relying on ostensible representation. And I won't take up...
Well, is that necessarily so? Because the indoor management rule is to redress a particular problem which arises from companies who have public documents of which a person acquires constructive notice. And therefore it's a limited relief for third parties.
It's a relief
of a completely different in a completely different context. It doesn't apply to a Bermuda exempted.
Perhaps I didn't make myself clear. The rule in Turkwind that is, your ladyship's right, is concerned with putting third parties in a position where they're entitled to assume that internal management has been properly conducted. But the point is, as a matter of law, you're not entitled to do that if you're put on inquiry. So, in other words, you don't get the benefit of that. All I'm saying is, where you're relying on ostensible authority, equally, in other words, you're looking at conduct of the company. There's no reason in our submission why the law is any different as to the appropriate test. Can I just...
Well, just on that, might it not be said that the rule in Turkman's case is actually wider than ostensible authority because it stems from the public documents of the company. So it's not necessarily implausible that the law should have developed in a different way with a particular answer to the rule in Turkman's case based on being put on inquiry, which does not necessarily apply across in the case of ostensible authority, which is narrower.
Well, the point, yes, I mean, the point that the authors of Bousted make is perhaps they put it more eloquently than I do, and that's why I'd just like to show you what they say. It's in volume 9 at page 3125. And so paragraph 8049, they refer to Akai and introduce it. Then at 8050, they say, they refer to the fact that the case has been followed in the last sentence of 8049 in a number of English cases. And the first one they refer to, if I can just if you'd like to note, is the Quinn case that you were given a copy of. We don't need to turn it up. In that case, there doesn't seem to have been any argument in the court about Akai, in that it wasn't actually referred to by counsel, and it was the court itself looked at it, and so the court didn't have the benefit of any argument of the type that you're now having. So in my submission, notwithstanding, obviously, again, an eminent commercial judge, Lord Justice Gross, but the point hasn't been considered. Also, if one looks at that judgment, you will actually see it's inconsistent with the Raffaella. Perhaps we'll come back to it and I'll show you why it's inconsistent. But looking at this next paragraph here, you see it's respectfully suggested that this development is based on a misunderstanding of prior authorities and of general principle, and that's important. For most practical purposes, what it is at issue is whether the principal is bound to a contract with the third party. In principal-to-principal contracting, it's very clear the issue whether the parties have intended to contract and the terms on which they have contracted are judged from the position of the reasonable person, with such person's knowledge of observable facts, not the unreasonable yet rational person. The same approach as we've seen is taken in establishing a representation of authority. It would be surprising to look for reasonableness in assessing whether a representation was made in the first place, but throw that over when assessing whether there were countersigns. The cases prior to Akai drew no such distinction. Insofar as many of these cases involve companies, it's not the case the courts were taking a stricter stance in favour of companies than they would with individuals, but rather the opposite. The courts were insisting that companies cannot be made more readily liable in contract than an individual on the basis of a simplistic reliance by third parties on the rule in Turquins. As is explained above, that rule is concerned only with procedural irregularity. It does not affect the ordinary requirement that the third party show that he dealt with someone with actual or apparent authority from the company to make the contract. The company cases, therefore, are mainstream agency cases. Nor is there a universal principle that a representee is not required to look behind a representation. If there were, it would be inconsistent with the rules for contract formation. Indeed, the notion for not needing to look behind a representation operates mainly in the law of misrepresentation, where the representee is using the representation to deny or alter what might otherwise be a contractual obligation, not to create one. This is the position with most of the cases on which Lord Neuberger relied in the Akai case. Otherwise, in the absence of evidence of actual intention that a representation be relied on, as in the case of fraud, reliance on a representation needs to be reasonable. And we've seen that in the Raffaella. In short, the no inquiries rule operates at common law only where what is sought is rescission, or in cases of fraud, damages for reliance loss. It cannot be relied upon to make a contract. Even within the sphere of its operation, the cases conclude that in the absence of obfuscation, the no inquiries rule only applies to unequivocal representations, not to ones where there's ambiguity or a series of inconsistent statements. Finally, it should be recalled that the operation of estoppel by representation within the concept of apparent authority is a somewhat tenuous one. It would be remarkable, therefore, if the law were to treat a representation founded solely on the principal's conduct, there being no verbal communication directly between the principal and the third party, as virtually conclusive, even though a reasonable person would have spotted counter-signals and inquired about them. The point was well made by Mr. Justice Brennan in Northside, and you can see the quote. So in this regard, it's suggested the process of determining whether apparent authority is made out is ultimately a single process rather than a rigid two-step process of finding a holding out and then inquiring as to the third party's state of knowledge. And that latter point is really the point I've been making, that that's where you get into, if you start splitting things up, that's when it becomes artificial. Ultimately, you're asking, was there a representation on which it was reasonable to rely? And if there are contraindications that a reasonable person would not assume somebody had authority, then you need to inquire and you can't say it was reasonable for you to rely.
And nor, as I understand your argument, can you rely on Turkin's case to, in some way...
I'm sorry?
Nor can you rely on the Turkin principle, the Turkin case, to in some way make good the deficiency
exactly.
in the position of the person making the representation.
That's right.
Yeah.
And just
to pick up that passage you
yes.
read from Bousted,
yes.
that's the most recent edition, 21st, which I see is December 2017,
Yeah,
but it probably reflects the views of Professor Peter Watts,
it does.
whose article you've given us from 2015. That hasn't, as far as you know, been commented on in any judicial authority as yet.
Not as far as I know.
And is there, I mean, you mentioned in your footnote, you mentioned Chitty, but I couldn't find anything.
No, I don't think there's anything in Chitty that is particularly...
So there's no other relevant academic comment that we should see.
There was an article in the LQR which I haven't read. Did you read?
the one that we've put in the authorities.
2013?
There's a 2015 article from...
That's in the LCM.
Watts.
That's the Lloyd's Maritime.
Yeah.
Which is also Professor Watts.
Yeah, the Watts
And
article.
that's making very similar
Professor
points.
Matthew Koeniglin and Professor Nolan wrote an article in 2013 in LQR, and I'm sorry I haven't had time to read it.
I haven't read that, I'm afraid.
Would your learned junior be prepared to do so?
Well, we'll certainly dig it out. And,
Wait, is this a recent one?
2013.
Hmm.
So,
Or you've dug that up on your online?
would have done, I'm prejudiced.
No, I mean, it's obviously a significant point. Whether we need to deal with it is another matter, but if we do, then we obviously need all the help we can get.
yes, I mean, potentially, it's a point which is of broader significance than...
I mean, your point is basically the law has been well established from 100 years or so.
Yes, that that Akai, when one starts to apply it to a particular situation, is in our submission is actually plainly out of step. The reasons actually that Bousset are making, and that if a reasonable person would not understand that there was authority, it's very odd to say that the company should be treated, because somebody acted unreasonably, as having authorised a transaction. And so, in our submission, the oddity about Akai is actually the facts were very extreme, and so there was no authority. Can I just, before we move off the point, could I just also just show you the Quinn case, because that is shown of the Court of Appeal. And
Haven't yet found it.
it was given to you yesterday.
Loose, thank you. Thank you, Mr.
Actually, I slightly misstated the position as to how. So if you go to paragraph 17, you'll see that the court said that counsel had drawn attention to a number of authorities, and then after that sentence, counsel advanced submissions on the recent decision in Akai after the court alerted them to this authority. So counsel did make submissions on it having been brought to their attention. But when you go to paragraph 23, where the Court of Appeal deals with the matter, they, at 23.1, simply, as it appeared to adopt the approach in Akai without further consideration. And then at 2, what is said there is actually not entirely accurate. So the Court of Appeal says, however, and consistent with the principle in the field of misrepresentation, the question of the reasonableness of the third party's belief is neither here nor there. As you've seen, that as a general proposition is entirely wrong. And then they quote from Spencer Bauer, a man who's told an untruth, innocently or fraudulently, cannot complain that the representee acted on the faith of his misstatement in the manner in which he, the representor, intended that he should. He can never be heard to say that another should have not have believed the lie he was told for the purpose of inspiring that belief, or plead that if the representee had not been such a fool, no harm would have been done. The representee never owed a duty to the representor to be careful, to be active in suspicion, or diligent in research. But that's dealing with the situation. It's usually the fraud situation where you make a representation intending the representation to have a particular effect. Now,
I follow that, but the way it's put
Yeah.
here it specifically refers to innocent.
yes, but you've got to have told an untruth, and you've got to have intended. So you may not be dishonest, but you've got to intend that the representee should understand you to be saying what you've said. That's the critical point.
The title sort of gives gives one guidance. Actionable misrepresentation. And it's dealing with claims for damages, for example. It's not dealing with ostensible authority.
No, that's right.
Well, the issue is whether the principal is bound by a representation which was not reasonably relied on.
Yeah. And his lordship, at the top of the next page, says that the observations of Lord Newberger and Akai are to the same effect. But I've already shown you that it's inconsistent with various lines of authority. Now, I'm not seeking to be critical of Lord Justice Gross and the other members of the Court of Appeal. One can see this point, how it arose. So, now, in our submission, of course, none of this actually really makes any difference in this case because of what I've already made submissions about on the representation, or his absence of representation, the absence of reliance. But we do say that the Court of Appeal was correct that the circumstances of this transaction were such as to put PT Satria on inquiry, or such, another way of putting it is that it was not reasonable for them to conclude that Mr. Jones had authority. And we endorse the points which are made at paragraph 132 of the judgment of the Court of Appeal, A to D and G to I. And
in that analysis, can one take into account that Satria were also going to get a benefit out of the whole event?
oh yes,
Because
absolutely.
they were getting a quick way into the license to exploit the geothermal energy.
I mean, again, very much so. And you'll remember in Akai, that was...
Indeed.
You have to look at the two sides of the coin. In Akai, the counterparty was getting... essentially in that transaction, remember what was being given were guarantees. And the party providing the guarantees was getting no benefit. The other party was getting an enormous benefit.
It's a switch.
Yeah, exactly. Now, in our case, of course, PT Satria, this, for them, I know we have those references to Mr. Suhardno referring to this as a trash project, but the point is the reason they were doing this was to get their hands on what was potentially a valuable right. So they're getting the rights. They know, I mean, I think this is the thing that's absolutely critical. They know that EACL is actually immediately getting nothing. And a point that is made well by Justice of Appeal Cavalier, if I can just remind you of that, is that it's at paragraph 182 of the Court of Appeal. And I think what one has to if one just, before we look at that, if one just thinks about this commercially for a moment, EACL, or Mr. Watabe owns 100% of the shares in EACL, which is his holding company. Now, EACL, of course, if he wants to keep it alive, he will at some point have to make sure that the company fees are paid. But you can, even if you don't pay them, you can then pay them and you will restore things. So it's a pretty minor point. But EACL then owns 100% of the shares in Bell. Now, Bell may be, it's obviously been funded in the past, may be underwater in that it's got a lot of liabilities. But on the other hand, it has a very significant asset. And you may remember Mr. Lord Justice of Appeal Clerk referred to Mr. Hatter's evidence that once the debts had been cleared, he thought it was worth $60 million. So this isn't something that's, just pie in the sky. And yes, it's a project that may require a lot of investment to get return, but there's nothing particularly unusual in that. But if you're looking at it from EACL's point of view, they have a valuable asset which they don't have any liability for the debts of BEL. So, I mean, that's the nature of corporations, and since Salomon & Salomon, that you as a shareholder are entitled to walk away, but you can try and exploit the position, and so you may own the shares in a company which at the moment has a lot of liabilities but has an asset, and you can hope that somebody else will come and take it off your hands and you can sit and wait. And that's the point that Mr. Lord Justice Cavalier makes at 182, where he says that on the facts of the present case, it's impossible to draw a clear demarcation line between the substantive decision of EACL, which was not itself insolvent, to sell its shares in BEL to meet BEL's liabilities, and the supplemental decision of Bell to approve the transfer. The governing commercial decision to sell EACL's main asset was very much a matter in which the interests of EACL's sole shareholders were still alive. And just stopping there for a moment, that is obvious that the shareholders of EACL were very much interested in the terms on which, if any, the asset was sold. The conundrum which faced Jones and Hatter as directors of Bell was not unique. They properly requested a capital injection and one was not forthcoming. Neither EACL nor AOL could be compelled to provide the capital injection. The raison d'etre of limited companies is to permit shareholders to chance their arm at receiving the upside benefit of profits without being exposed to the downside of liability for the company's debts. The directors were indeed in these circumstances entitled to have regard to the interests of Bell's creditors, but their proper recourse was limited to making decisions on behalf of Bell itself. He's there clearly talking about when they're acting on behalf of Bell. Legitimate and well-recognised responses to the quandary of Bell's insolvency and the lack of shareholder support available to Jones and Hatter included the options of resigning or threatening to resign, petitioning or threatening to petition to wind up Bell, or petitioning to wind up Bell and appoint a provisional liquidator. It was not for employee directors of a solvent company to decide without recourse to a shareholder what course of action was in the shareholder's best interest. At the EACL board level, where the only substantive decision was actually made, the relevance of the personal interest of the two directors of being paid their outstanding salary by Bell and the extent of their apparent authority was fundamentally different to the corresponding position at the Bell level. At this corporate level, the insolvency of Bell could not justify employee directors liquidating the intermediate holding company's principal asset over the objections of the sole shareholder to satisfy the subsidiary's debts. Now, of course, the PT Satria don't know the full story, but what they do know is that what is being done is selling off the sole asset. They do know that Mr. Jones and Mr. Hatter, as creditors of Bell, are going to benefit, and that the EACL is going to get little or nothing. I think we've set out sufficiently in our case, and then we rely on what is in paragraph 132, as to why we say any reasonable person would be put on inquiry and could not proceed on the basis this was authorised without, at a minimum, seeing a board resolution or board minute, and indeed, probably one would actually may want to go further, but I don't need to make that point because they didn't get even that minimum. What they got instead was clauses 6 and 7 of the HOA. And from a commercial point of view, that was something they were entitled to do, to say, well, I want you, Jones, and you, Hatter, to give me a contractual or an undertaking that this is authorised, and I'll come after you if it's not. But that's a different matter. Now, so that concludes my submissions on the ostensible authority part of the case, and then that takes me on to the next part of the case, which concerns the board minute of the board meeting of the 1st of March. So the first question that one needs to consider is the question of conflict of interest, which the Court of Appeal dealt with at paragraphs 88 and following. Now, did Janose and Hatter have a conflict of interest? Now, I emphasise that they did is not, in fact, the subject of the appeal. All of the grounds of appeal and anything that went into the statement of facts and issues proceeded on the basis that there was, in fact, a conflict of interest. And so that's a matter for your lordships as to whether you permit this appeal to proceed by reference to the question as to whether there was. But I'll address it, even though I say it's not open. Now, Mr. Janose and Mr. Hatter were directors of both EACL and BEL, and therefore they owed duties, fiduciary duties, not to put themselves in a position where their personal interests conflicted or might conflict with their duties owed to EACL and BEL. And at volume 8, at tab 22, is I don't think we need to turn it up, is the Bray and Rawlinson Ford case, and we're all very familiar with this line of authority. Now, perhaps we could, well, you've seen the Bermuda Companies Act, but could I just quickly go back to it in volume 9, tab 32. I think you were shown yesterday, section 97.
Could you please just give me the page again?
Yes, I do apologise, my lord. It's page 2944.
Thank you.
So 97.1, every officer of a company in exercising his powers must act honestly and good faith with a view to the best interests of the company. And 97.4 deems them not to be acting honestly and good faith if, at 4b, they fail to disclose at the first opportunity at a meeting of directors or by writing to the directors an interest in any material contract or proposed material contract or material interest in any person that is party to a material contract, or proposed material contract. And 97.7 provides that nothing in this section should be taken to prejudice any rule of law or any bylaw restricting officers of a company from having any interest in contracts with the company. So one actually has here essentially three things in play. You have the specific provisions of section 97. You have the provisions of the law generally about fiduciaries not having a conflict of interest. Then you have the specific provision of the bylaws, which are in volume 5 at 1733. Well, the relevant part is at 1733, which is bylaw 52.2. A director who is directly or indirectly interested in a contract or proposed contract shall declare the nature of such interest as required. Following a declaration, and unless disqualified by the chairman, a director may vote in respect of a contract or proposed contract in which he is interested. And now, while we have volume 5, can I just ask you to turn back in it to page 1628, which is, so that is the notice of the meeting of the board. You can see the so this was served on the Saturday for a meeting the next day, and you can see the purposes of it were, I mean, it was a meeting to be held via Skype conference call at 10 a.m. Japan time for the purposes of considering the following items of business. You can see 1, appoint a chairman and confirm quorum, review and approve previous minutes, share transfer cancellations, share transfer approval, any other business, and close. And on the next page at 1629, sorry, before we look at that, and there was a similar one at page 1626 for Bell. And you can see at 1627 that that was sent to Mr. Yamura by fax, the requisition in relation to the board of EACL on the 28th of February at 4:55 p.m. And at 1629 and 1630 were letters which were sent to these individuals. So at 1629, Mr. Yamura said he wrote in response to the notice of board meeting sent by Jones by email on the 28th, purporting to convene a meeting of the board, etc., to deal with, amongst other things, the cancellation and approval of share transfers by whom and to whom is not indicated. I wish to note I object convening this board meeting for the following reasons. Firstly, I'm not able to participate by Skype, which is not a valid, reliable means of communication. There's no physical location or dial-in number stated on the notice to enable me to attend. Secondly, the shares of the company are wholly owned by AOL, and therefore no dealings in the shares of the company can be approved without the involvement of the sole shareholder. Thirdly, as you're fully aware, a special general meeting has been convened by the sole shareholder to be held on the 4th of March at 10 a.m. to remove both you and Mr. Hatter, and you should not therefore be approving any actions which relate to the assets or shares of the company. Now, just stopping there for a moment, what's actually interesting about this is that Mr. Yamura clearly understood share transfer approval to be talking about the shares of EACL. But the Court of Appeal has held that the notice was a valid notice. I think Mr. Todd at some stages in his submission said the meeting was a valid meeting. They've held the opposite. It wasn't a valid meeting, but they upheld the argument that the notice was valid. Now, and we haven't appealed that. Now, at 1630, is the letter that was then sent by Mr. Yamura and the two Messrs. Matsumoto on behalf in relation to Bell. And I won't read it all out again, but you can see in the third paragraph, they said, secondly, the majority of the shares in the company are wholly owned by East Asia, and its sole shareholder, Affluent Ocean, has convened a special meeting to be held to remove both of you as directors of EACL. Further, we've convened a special general meeting to remove both of you as directors. Therefore, you should not be approving any actions which relate to the assets or shares of the company. We reject the purported convening of the board meeting. Now, in our submission, is extremely difficult to see, firstly, on what basis Jones and Hatter thought they honestly could proceed, and certainly without making full disclosure of the terms of the HOA and the benefits that they were to receive. The evidence of Mr. Hatter, which Justice of Appeal Clark referred to at paragraph 93 about the company, once its debts were cleared, being worth $60 million, is in volume 1 at page 287. It's referring to correspondence the previous year. It's page 287 at the foot of the page. The questioner asked him at line 23, you say in this case, I believe Bell shouldn't accept any offer lower than $60 million US. And on page 288 at line 5, he says, that's what I valued at the shares at, on the condition that all of Bell's financial liabilities were taken care of, meaning the company was free and clear. Then at 289 at line 11, so you're saying that if in fact the company's debts were cleared off, it would be worth 60 million. Potentially, okay, potentially yes. But the heads of agreement, which we'll get to, the company's debts were to be paid off, and you were prepared to sell it for 2 million. It's going to the same entity. The buyer is the one who's covering the liability there. That's totally different from the company being freed and cleared of its financial liabilities. But if the company was free of its liabilities, no matter who assumed it, the shares would be worth $60 million, according to what you've said. I was suggesting that Bell not accept an offer below 60 million. It would have been up to me to do the sale. And you were the most experienced one, knowledgeable about Bell and EHCL and what they were doing and what they were worth internally. Yes. So, in our submission, you have a situation where Jones and Hatter both had an obvious financial interest in the transaction. As a result of you've seen clause 3C of the HOA, they stood to get about $500,000 between them. And they were also being put in a preferential position to other creditors. And so in our submission, the suggestion that there wasn't a conflict of interest is entirely hopeless. The conflict was a conflict between the personal financial interests of these two gentlemen and the duties which they owed to EACL and insofar as it matters to Bell, but the focus is on EACL. The fact that they each had a financial interest created an obvious risk that they would take those interests into account in performance of their duties. And that's what this area of the law is all about. It's protecting people from that very risk. And can I ask you to look at the passage from Snell, which we quoted, but if you look at it more fully, it is helpful in volume 9 at tab 38. And page 3142, my lord. It's this is all sort of well-known stuff, not at all controversial. One sees conflicts between duty and interest, general principle. It's an inflexible rule of the Court of Equity. A person in a fiduciary position is not allowed to put himself in a position where his interest and duty conflict. The rule applies even where the fiduciary's personal interest possibly may conflict with his duty, but only if a reasonable person, looking at the relevant circumstances, would think there was a real sensible possibility of conflict. Thus, if there's no non-fiduciary duty in the circumstances, there can be no conflict between duty and interest. The fiduciary conflict rule has sometimes been attributed to considerations of morality, but the better view is that it's based on the fallibility of human nature rather than on morality. It's based on the consideration that human nature being what it is, there's danger in such circumstances of the person holding a fiduciary position being swayed by interest rather than by duty. By having a personal interest in a transaction which conflicts with his non-fiduciary duty, the fiduciary puts himself in such a position he has a temptation not faithfully to perform his duty to his employer. It's the temptation to breach non-fiduciary duties that is the evil against which the rule is directed. Thus, in Aberdeen Railway, Lord Cranworth identified a director owed a duty to his company to obtain property for the company's use at the lowest price possible, and observed that the director's personal interest in a transaction would lead him in an entirely opposite direction. It is not necessary to show there has been a breach of non-fiduciary duty in order for there to have been a breach of fiduciary duty when the fiduciary acted in circumstances involving a conflict between that non-fiduciary duty and his personal interest. It's quite enough that the thing which he does has a tendency to interfere with his duty. Indeed, a fiduciary can be in breach of the fiduciary conflict rule, even though his or her conduct has been to the benefit of the fiduciary's principle. The rule is a general one based on generalised considerations of risk, rather than one which requires an assessment of whether the fiduciary has actually succumbed to temptation, as that is often too difficult to determine. In that sense, fiduciary doctrine is often described as prophylactic. Similarly, the fairness or otherwise of the transaction is generally not a relevant consideration, and no inquiry on that subject is permitted, nor is it relevant whether any gain by the fiduciary was one that the principal could or could not have obtained. The honesty or otherwise of the fiduciary is also irrelevant. A breach of fiduciary duty may be attended with perfect good faith. The fiduciary conflict rule might be departed from in many cases without any breach of morality, without any wrong being inflicted, and without any consciousness of wrongdoing. That does not mean the rule can be departed from where the fiduciary does not act immorally. It means that the rule applies irrespective of considerations of morality, and the rule is not avoided by the fiduciary arranging a transaction through a third party if there's an understanding or agreement in honour or any other shape, with the effect the third party is in fact acting on behalf of the fiduciary. Now, in our submission, this is an absolutely classic case where the decision whether or not to enter into the HOA, or ultimately the decision whether or not to affirm it, was one that could only properly be made by the board, and could only be properly be made if proper disclosure was given. Now, none of this is in fact affected by discussion about relative solvency or insolvency of the two companies. The reason for that is, firstly, if you have a situation where, if we take BEL for a moment, which the evidence showed was insolvent and significantly so, with significant liabilities, the only effect of that is that the directors, when considering the interests of the company, have to take account of the interests of the creditors, which would not be something that they normally have to do. But that doesn't mean that they're absolved from their duties not to have a conflict of interest.
I mean, they always have fiduciary duties owed to the company.
Exactly.
It's just who the company, if you like, represents.
Exactly so.
If it's insolvent, it's the interest of the creditors.
Exactly.
If it's solvent, it's the interest of the shareholders.
That's right. And therefore, it's saying, well, Bell was insolvent, it doesn't make any difference to the question whether they had, obligations under the Companies Act and the bylaws to disclose, and secondly, obligations as a matter of general law to avoid conflicts of interest. And so one needs to be careful about getting, as it were, misled by thinking, well, somehow it makes a difference that you're in an insolvency context. As my Lord Sales says absolutely correctly, the only difference is, in the case of Bell, is that the interests of the creditors may become paramount. Of course, in the case of EACL, there was no evidence that it was in fact insolvent or had any significant liabilities. Indeed, there was no evidence that it had any liabilities other than to pay company fees. Now, even if you say, well, that was a debt, this wasn't a transaction which was being entered into in order that you could get money to pay off those fees. As it happens, they weren't even getting any money to EACL for that purpose, so they weren't even protecting its position. Now, the relevant question, as was identified at paragraph 93 of the Court of Appeal, is, so far as EACL is concerned, is whether there was a conflict of interest between Jones and Hatter on the one hand and EACL, which was not insolvent and had no sizable liabilities, on the other. And I don't need to read it out, you've seen all of that. The circumstance of this case, it's self-evident that there was. But even if EACL had been insolvent, it doesn't absolve, only really repeating the point, doesn't absolve the directors from the obligation to make disclosure and their obligations as a matter of law to avoid conflicts of interest. And so, and that's a point that you saw being made by Justice of Appeal Clark. You can see makes that at 93, but he also makes that point at 99 and 100, because he's there considering the position of Bell, which was insolvent. So at 100, he considers 100 and 101 that they breached their fiduciary duties to Bell as well as to EACL. And Mr. Justice of Appeal Cavalier deals with the point also at 182 to 3.
What Justice of Appeal Cavalier was saying was that as creditors, they should simply have put on a winding up petition or something to that effect, which would have brought the whole enterprise to an end, rather than see how the creditors
as
were
the
paid.
creditors, they were
It's a difficult
entitled-
position for
as
could
credi-
be a difficult-
I'm sorry, I didn't mean to interrupt.
No.
As creditors of Bell, they were entitled to do that. As directors of Bell, simply wearing their hats as directors of Bell, they could have said, well, we are going to take steps to cause Bell to be wound up. But what is slightly odd about this case is where you're in a position where you were a director of Bell, but you're about to be removed, and nothing was imminently happening in relation to Bell. It's a very odd thing to then, as a director of EACL, sell off the shares. And one could see a situation, let's say, as a director of Bell, let's say in a hypothetical situation, something happened on the 25th of February, and although they know they're about to be removed on the 4th of March, there's some step you need to take to protect the creditors of Bell, say, or to protect the shareholder of Bell, and that they felt compelled to take that. But that's not our case. But we're not in the Bell situation here, we're in the EACL situation. Now, could I just, although it may not matter very much. You will remember that in Justice of Appeal Clark's judgment, he referred lost the reference. Yes, at paragraph 95, you remember he referred to the Neptune and Fitzgerald case, which was the, back in 1995, Mr. Justice Lightman, considering the position or under then English statutes of a how disclosure has to be made. Now, the reason Justice of Appeal Clark referred to that decision at paragraph 95 was to explain the policy behind disclosure and how you have to, at a board meeting, the purpose of even where everybody may know the facts, you had to make disclosure is to remind people of their responsibilities in this area.
But Mr. Todd referred to another decision, I think, of the Court of Appeal, in which it was said the disclosure could be informal. But anyway, it doesn't matter. But I've got the point from 95, yes.
Yeah, but no, the point I think Mr. Todd, made, and I was just going to refer to it, I think your ladyship said, well, this position has been superseded under the English Companies Act. I mean, it has to an extent, but it's not it's now just slightly different. Now, I can go into that and explain it, but ultimately the position here, of course, we're concerned with the Bermuda Companies Act. So whatever change happened in 2006 in England is neither here nor
yes,
there.
but the decision of the Court of Appeal, which I seem to remember Lord Justice Simon Brown, as he then was in it, dealt with the possibility of an informal disclosure. But it doesn't matter because it's clearly a very important element of a director's duties to disclose a conflict.
Yes.
That's the basic equity.
That's the point that was being made.
Yes, and your point.
And in our case, we had no disclosure at all. I mean, because they haven't, at the board meeting, they don't disclose. They didn't take any steps otherwise outside of the board meeting to disclose. And indeed, you've seen the requisition, and in fact, you see the odd thing about this, the reason I wanted to show you the way that correspondence went, that it's perfectly clear that those representing the shareholder of EACL didn't actually understand that the board meeting was actually going to be concerned with disposing of the shares of Bell. Now, the Court of Appeal, in a way, have said, well, that's, in terms of the board meeting itself, that's too bad for you if you don't turn up. But if you're asking, well, have you disclosed and could you have thought you'd disclosed, anybody seeing that correspondence would realise that they don't know what you're actually up to.
Absolutely.
And so they were then asking, have you somehow relieved yourself of the obligations you have under the Bermuda Companies Act, under the bylaws, and at common law to disclose? The answer is an overwhelming no. Now, my Lord, so those are my submissions why there was patently a conflict of interest, which applies both in relation to, of course, the entering into the HOA, if one said that was, contrary to my submissions, if that were treated as within their ostensible authority, or Jones's ostensible authority, and this board meeting. Now, in relation to the board meeting, the consequence of this is that, well, sorry, if I can say this, there has been no argument raised either in writing or orally by Mr. Todd that if there was a conflict of interest, that that disentitled and disqualified these individuals from voting. So I simply don't know what point, if any, is intended to be pursued on that. I think it's sufficient for me simply to say that as a matter of law, as the Court of Appeal found, they were both disqualified because they hadn't complied with the bylaws or the law. And so the effect of that is that the meeting was inquorate. In other words, there was no relevant board meeting. As I say,
that would be in the nature of an irregularity.
Well,
the Turquin's case.
Yes, that's right.
And presumably there are cases, I appreciate you say not this one, but where, let's say one director is interested in a contract, makes disclosure to his fellow directors, and they say, well, thank you very much for telling us, but you may now participate with us in considering, as a member of the board, whether the company should enter into that particular contract.
Yes.
So presumably, the mere fact that a director has an interest in a contract does not disable him from participating, provided that full disclosure is made and the other directors are happy that he should participate.
Precisely so. No,
right.
That's what the bylaws are saying. But once you've made your disclosure, you're allowed to vote.
So is your point when you're saying the meeting was inquorate is that there hadn't been disclosure to, well, in this case, the other director, Mr. Yamura, whose consent would have been necessary for them to continue to participate?
There certainly hadn't been disclosure to Mr. Yamura, nor was there disclosure at the meeting itself. And that's what you would have to do. You have to have disclosure at the meeting.
I wonder about that. I mean, because the Bermuda Act talks about meeting or otherwise, I think. It didn't specify that it had to be.
Oh, yes. Well, if you wanted to say, sorry, you could have, if you'd made disclosure to all the directors, say in correspondence beforehand,
yes,
then that would probably be sufficient.
Yes.
Where you have a situation where you haven't done that, you then just have a meeting, that's all that's happened. Then at that meeting, even if both of you know the terms of the HOA, you have actually got to, as it were, formally make disclosure at that meeting. That's essentially what comes out of that Neptune case.
Well, I wonder, well, we haven't looked at Neptune. I have dimly at the back of my mind, but it is dimly, that Section 317, as it used to stand, was fairly prescriptive, that
yes,
there had to be disclosure at a meeting.
Yes.
But the Bermudan statute is not prescriptive in that way.
Well,
I could be wrong about that.
Yeah,
but
well, let's just...
I'm just, if you like, putting down a marker. That
I'm just wondering, my lady asked a question a moment ago about whether the absence of disclosure of the conflict of interest would be a procedural irregularity of a kind to which the rule in Turquin's case could apply, and you accepted that it could. I'm just wondering where that point goes.
No, sorry, well, if I did accept that, then I may have misheard or misunderstood. The rule in Turquin's case has got no relevance to this issue.
Well, that's rather what I thought.
Yeah, it's got absolutely no relevance to this issue. Because this isn't a situation where the other side are relying on the board minute because that was shown to them or anything of that sort.
Yeah.
So if you had a situation where there is a board meeting and the board minute is shown to them, and they, in reliance on that, they enter into the HOA, then a question may arise as to whether the rule in Turquin allows you to assume that disclosure was made.
Yes.
But
well, I wonder, we're going to have to adjourn now, but I think some of us felt it wasn't quite clear from Mr. Todd's submissions what exactly his position was about this. And I'm not asking that you clarify it here and now, but no doubt Mr. Howard would be interested to know what your position is, and perhaps it would be clarified for us at 2 o'clock.
Clarify.
Right, we'll go ahead.
If you like.
Yes.
Our position is this, that Turquoise, if one actually looks at the decision itself in Turquoise, which is in volume 7, tab 2, what that provides is that a third party, even where a resolution is required of the board, an innocent third party dealing with the company is entitled to infer, and that's the wording in Turquoise, is entitled to infer that a resolution has been passed, the requisite resolution has been passed. So that is what we say.
Where does that go in this case?
What that goes to is this, that where the company with whom PT Satria has contracted, assume that for present purposes, seeks to avoid that contract by reason of some internal procedural irregularity, the third party against whom that case is set up by the principal can say, I'm not affected by that irregularity, which you're now seeking to rely on, because that is a matter of internal management, and I'm not affected by such matters. So, it doesn't matter. So, I'm sorry.
So really, the point you're making doesn't depend on the meeting at all, does it?
Yes, it does, because it depends on, because we rely on the meeting to effect a ratification, that is an adoption of the contract by the principal.
So not avoidance then at all?
I'm sorry?
Not avoidance. I mean, you said where a party seeks to avoid a contract because of some internal irregularity, the third party can say, I'm not affected.
Yes.
But surely what we're dealing with this meeting is ratification of something which was not a contract, because of, we only get to this point in the argument if there was an absence of ostensible authority.
Then ratification is to cure the absence of...
Yeah, it's to cure an absence, but not to avoid a contract. It's to endorse as having been made a contract that in fact was not made.
A company can, by ratification and approval of a contract which was made without due authority, the effect of that is an adoption by the company, by the principal, of the very contract. Now, whether that was adopted validly has to be ascertained, or is ascertained by reference to the procedures which are necessary for that adoption. And what we say is this, that where a company has apparently passed a resolution, because we've seen it, has apparently passed a resolution adopting the contract, it is not open to the principal, i.e. the company, to say, aha, there is a resolution adopting this contract, but it was obtained irregularly by reason of some procedural irregularity. In answer to that sort of claim by the principal, by the company, the third party simply says, I'm not affected by your internal procedural irregularities. And I'm entitled to rely on the indoor management principle to prevent you setting up those irregularities as against me, the innocent third party.
And you're saying that even though the third party doesn't know these internal things have been going on at all?
Absolutely.
Right.
He doesn't even know there's been a meeting.
No, absolutely.
But he does know the next day that the meeting is strongly challenged.
Indeed, but
other part.
But my lord, I will invite my lord's and my lady's attention. I think my lady might know the case quite well anyway. To the actual decision in Turquoise, where what the court said is where a resolution is necessary. What has happened in relation to that? The general meeting. It's one page in Turquoise only. The general meeting, pursuant to its constitution, the board, the company could resolved to confer borrowing powers on the directors, and they purported to do so. The company in general meeting purported to do so in such amounts as the directors may from time to time determine, or words to that effect. So it required a further resolution. That was the authority conferred on the directors, but it obviously required a further resolution by the board to determine the amount before any such borrowing could be made. And what the court, it is one page. If you would, there is it's literally 1 page and half a page of that 1 page. It is in volume 7. It's in tab 2. If it could, and it's at page, oh gosh, mine doesn't have a number on it. It's the last page of tab 2.
I'm bound to say that I do object to an argument along these lines, not having been put in a written case, not having been put in oral submissions, and now Mr. Todd is standing up. I mean, it really does put me at a disadvantage. I said yesterday I objected to the whole way the case was proceeding, and now, when I'm close to closing my argument...
Well, that's why I intervened when I did, because I noticed how Mr. Todd was reacting to your exchange with her ladyship, and I rather wondered if this might not actually be the crux of an important aspect of his argument. It rather sounds as though we should hear you at 2 o'clock, and I mean, we've flushed out, as it were, what the argument is, and now you know what it is, Mr. Howard. If you have an objection to its being run, then we should hear you on that.
Could I just clarify one point with Mr. Todd? Mr. Todd, I thought you had told us in opening that Satria did not know either of the minute or that there was to be a meeting.
Correct.
In answer to my Lord Carnworth, you said that they did know there was to be a meeting. So...
No, I didn't.
No, I don't think.
Oh, I'm so sorry.
No, I didn't
I misunderstood. So they didn't know that there was to be a meeting. They didn't see the minute. Sorry, that was.
You're really relying on the fact that they now know, and now that they know that there was this resolution, they rely on Turquin's case to enable that to cure any problem that there was with the HOA.
We rely on it to prevent the principle seeking to set aside by reason of procedural irregularity. And that is the case we've always made on this.
Yes, well, we'll hear you on this at 2 o'clock, Mr. Howard.